Hi, following up with a couple more responses to your questions. Picking up at Daniel's question about the second types of preliminary objections other than demurs. Do they have specific names other than that? Not to my knowledge, Daniel. They're generally preliminary objections relating to not complying with the rules in some way, but to my knowledge, there's not a specific name for them. And usually the relief asked for is requiring people to fix their pleading so that they do comply with the rules. Sheena asks, how long do you have to respond to preliminary objections? Generally 20 days. Sarah asks, would people in prison have any special treatment? Actually not, Sarah. I think civilian people that aren't familiar with the law would probably struggle managing preliminary objections. The only way that people do get some consideration, and I say this only because most prisoners are poor, is that you can request in forma pauperis, I-N-F-O-R-M-A, pauperis, P-A-U-P-E-R-I-S, in one word, forma pauperis, and basically it's asking for the ability to have the filing fees waived when necessary, and you'd have to fill out an affidavit and it would have to be approved by the court. But that's the only consideration. Otherwise, to my knowledge, prisoners don't get a whole lot of assistance that way. Hope asks, why did it develop? Hope, I kind of am not aware of some of the background. We are a fact pleading state. I think the more modern approach is a notice pleading state. Fact pleadings mean that you give detailed facts for every allegation that you make. Notice pleading, which is more in the federal courts, just gives people a general notice about what the parties are saying, with the thought that the extensive discovery in federal court will give people a chance to figure out more clearly what it is that people are looking for. And I don't know about it being adopted in other states. That is preliminary objections. In part, demurs are very similar to motions to dismiss, as someone else asked at the, I'm sorry for scrolling down, everybody, but I believe Britannia has asked, are they similar to motions to dismiss? And yes, they are similar. They're just done in a slightly different format. Costs of filing preliminary objection. That should generally run about $53, the same as motion costs. Hannah asks about scandalous and impertinent matter, as does someone else a little bit later. Scandalous, I haven't seen it personally very often, but there are cases where people will make allegations that are kind of beyond the pale. In other words, if you said somebody was a mafia member, or you called them names, and believe me, it does happen in litigation sometimes, you can file a preliminary objection to have that struck from the pleadings. Avinia asks about if you get an agreement in arbitration. Agreements generally only come in mediation. Arbitration, you usually get a ruling, and once you'd reach an agreement in the case to resolve it, you wouldn't deal with preliminary objections anymore. I hope I've answered your question. That's what I sort of understood you were saying. Emma also asked about scandalous and impertinent matters. By the way, impertinent matters mean things that just don't belong there. If you went on and on about something that really had no relevance to your cause of action, that would be impertinent. And again, scandalous is oftentimes akin to name calling. These are preliminary objections. They are only in the Commonwealth courts, in the Court of Common Pleas, etc. They're not in federal court. In federal court, if you don't like the pleadings, you can file a motion to dismiss, or you can ask for a more definite statement from the party, asking people to provide more information. Rebecca asks about all preliminary objections being filed at once. Let me see if I can explain it again. I think it's confusing with respect to the ability to amend a pleading. If I file, say, almost any pleading, an answer, a counterclaim, if the other side suggests that it wasn't detailed enough and files a preliminary objection about that, asking me to provide more information, I can, within 10 days, decide that, maybe they're right, and I can amend the pleading. If I do, it makes that preliminary objection moot. That is, it's of no moment, it's of no substance anymore because I've done what they asked. If, and this can happen, in the amended pleading it's still not good enough as they see it, they can file another preliminary objection to my amended pleading, and if I want, I can have the judge decide that, or again, I could amend it if I thought that it was valid. Johanny asks, how many judges decide preliminary objections? That's generally just one, and yes, issues of law are often challenged by way of preliminary objections. So that's all I have to say, everybody. Thanks.